Ich begrüße euch und Sie sehr herzlich zu dieser Veranstaltung, die wir hier heute machen. Ich glaube, dass das eine sehr wichtige Veranstaltung ist. Und ich möchte als erstes sagen, dass wir deutsch-englische Übersetzung haben, sodass jeder sich seine Kopfhörer nehmen kann. Und ich hoffe, das funktioniert. Sonst bitte ich um Protest. Also, wir machen hier diese Veranstaltung heute über die Sanktionspraxis der EU. Und es ist die zweite Veranstaltung, die Michael von der Schulenburg und ich zusammen veranstalten zu diesem Thema. Die erste war im vergangenen Jahr. Wir haben ein Rechtsgutachten erstellen lassen zu den Sanktionen, die die EU verhängt. Und dieses Rechtsgutachten war von der ehemaligen Richterin am Europäischen Gerichtshof Ninon Kolnerik und einer französischen Rechtsprofessorin Alina Miron. Das war die erste Veranstaltung, die wir dazu gemacht haben. Das Rechtsgutachten zu dem Thema liegt auch aus und kann sich jeder mitnehmen. Und bei dieser heutigen Veranstaltung wollen wir uns über die rechtliche Situation hinaus auch mit den konkreten Auswirkungen und der Situation der von den EU-Sanktionen Betroffenen beschäftigen. Und wir haben eingeladen für die rechtliche Situation, also für den Rechtshintergrund, Alexandra Hofer von der Universität Utrecht. Sie ist Sanktionsexpertin und wird später reden. Und dann haben wir zu meiner Linken, beziehungsweise von Ihnen gesehen zur Rechten, Juan Branco. Er war im Rechtsteam von Julian Assange und ist jetzt mit dem Fall von Nathalie Jamp befasst. Das ist eine Schweizer Kameruner Sanktionierte. Und er wird später zu diesem Fall erzählen. Und beginnen möchte ich mit dem Fall von Hüseyin Doğru, ein Berliner Journalist, der seit einem Jahr von den EU-Sanktionen betroffen ist. Also gegen ihn wurden im Rahmen der Sanktionen, die ausgesprochen werden, in Bezug auf, und ich muss das nochmal nachlesen, weil das irgendwie so kompliziert ist, wie das formuliert wird, im Rahmen der Entscheidung des Rates über restriktive Maßnahmen angesichts der destabilisierenden Aktivitäten Russlands wurden halt gegen ihn Sanktionen verhängt, also wie gegen alle anderen auch. Das ist die Rechtsgrundlage des Rates. Und die Sanktionen, die verhängt werden, bedeuten, dass unter anderem Finanzen eingefroren werden und die Reisefreiheit und andere Grundrechte beschränkt werden. Im Detail steht das alles auch in dem Rechtsgutachten, was dort ausliegt. Hüseyin Doğru, ich möchte mit seinem Fall anfangen, ist Gründer des Medienportals Red Media und ist halt von diesen Sanktionen seit einem Jahr betroffen. Wir wollten Hüseyin Doğru einladen als Betroffenen und haben das auch versucht. Und ich möchte ein bisschen schildern, weswegen er trotzdem heute nicht hier sein kann, weil das aus meiner Sicht schon sehr gut erläutert, mit welcher kafkaesken Situation wir es bei der Sanktionspraxis der EU zu tun haben. Wir haben vor 10 Tagen einen Brief an die sogenannte Zentralstelle zur Sanktionsdurchsetzung in Köln geschickt, die zuständig ist, weil Hüseyin Doğru ist deutscher Staatsbürger und natürlich irgendwie fällt unter die Obliegenheiten der deutschen Behörden und haben darum gebeten, eine Genehmigung zu erteilen, dass er an der heutigen Veranstaltung teilnehmen kann. In Kopie ist das geschickt worden, dieses Schreiben, an das Auswärtige Amt, an das Bundesministerium des Innern und an die Bundespolizei. Überhaupt erst einmal herauszubekommen, wo man dieses Schreiben hinschicken sollte oder wie man sich überhaupt an diese sogenannte Zentralstelle für Sanktionsdurchsetzung wenden kann, ist schon die erste schwierige Hürde, die man zu bewältigen hat, weil es gibt zwar eine Webseite, aber da steht nur eine Adresse drauf, keine E-Mail. Das heißt, man muss sich quasi erstmal durchtelefonieren, um überhaupt an eine konkrete Stelle das weiterleiten zu können. Das hat mein Mitarbeiter gemacht. Ihm wurde eine zentrale E-Mail-Adresse genannt und dort haben wir das hingeschickt, mit der Bitte um Weiterleitung an die zuständige Stelle und mit der Bitte um zügige Rückmeldung, weil das ja quasi vor dem heutigen Tag folgen sollte. Daraufhin geschehen ist erstmal gar nichts. Und dann habe ich angefangen nachzutelefonieren und irgendwie eine zuständige Stelle zu bekommen, die in der Lage ist, eine Antwort auf diese Genehmigung, auf diesen Antrag auf Genehmigung zur Ausreise für diesen einen Tag zum Zwecke der Teilnahme an der heutigen Veranstaltung zu erlangen. Und das war wirklich ein Geschehen wie in einem Roman von Kafka. Man hat also eine Zentralstelle geschaffen, aber die ist gar nicht zuständig, weil niemand richtig weiß, wer zuständig ist. Das heißt, also ich habe etwa, ich würde mal sagen, ungelogen 40 Telefonate mit verschiedenen Stellen geführt, um irgendjemanden zu finden, der mal in der Lage wäre, sich dazu inhaltlich zu verhalten, ob Hüseyin Doğru für eine Veranstaltung ins Europaparlament für einen Tag ausreisen und wieder einreisen kann, ohne Repressalien zu erlangen oder denen unterworfen zu sein, oder auch diejenigen, die ihm das Ticket zahlen, strafrechtliche Konsequenzen oder sowas zu befürchten haben, weil auch das ist im Rahmen der Sanktionen mittlerweile ausgeschlossen. Also der Bundestag hat ein Gesetz verabschiedet, dass halt die Unterstützungsleistungen ebenfalls strafbewehrt sein können. Also ich habe gesprochen mit dem Bundesfinanzministerium, mit dem Auswärtigen Amt, mit der Zentralstelle für Sanktionsdurchsetzung, alles immer diverse Male, mit der ständigen Vertretung in Brüssel. Und niemand hat sich zuständig gefühlt. Also gestern Abend habe ich noch mal an das Bundesfinanzministerium geschrieben, bei der Stelle, die man mir gesagt hatte, die zuständig ist für eine solche Genehmigung, und habe heute Morgen von Ihnen eine schriftliche E-Mail erhalten, wo drin stand, nein, wir sind nicht zuständig, wir sind nur für Finanzen zuständig. Wenn zuständig ist das Auswärtige Amt oder die ständige Vertretung, von denen werden Sie eine Antwort bekommen. Das ist bis heute nicht erfolgt. Und dieses Ganze zeigt einfach schon, dass dieses unsägliche Konstrukt, was Sie da gebastelt haben, also die Sanktionen werden verhängt auf Grundlage eines Beschlusses des Ministerrats der EU, also auf Regierungsebene. Durchgesetzt werden sie automatisch durch die Mitgliedstaaten. Und offensichtlich gibt es aber überhaupt keine Möglichkeit, da jemanden zu bekommen, der sich zuständig fühlt, beispielsweise eine Ausnahme zu machen oder der irgendwie bereit ist, sich damit inhaltlich zu beschäftigen. Also es ist wirklich eine kafkaeske Situation, weil es immer Rückbezüge gab. Finanzministerium sagt, Auswärtiges Amt zuständig, und Auswärtiges Amt sagt, Finanzministerium ist zuständig und so weiter. Das heißt, es gibt keinen konkreten Ansprechpartner und das betrifft halt diese gesamte Sanktionspraxis. Also die Sanktionen werden verhängt, werden umgesetzt, es gibt keine formelle Anklage, es gibt keine Verteidigung und es gibt nur die Möglichkeit, hinterher in einem aufwendigen Rechtsverfahren vor den EuGH zu ziehen. So ist die Grundlage der Situation, wie sie sich hier abspielt. Und das wird sicherlich jetzt erstmal Hüseyin noch aus seiner unmittelbaren Erfahrung weiter ausführen, was das konkret bedeutet. Was aber schon mal klar ist, ist, dass es die normale rechtsstaatlichen Prinzipien komplett ausgehebelt werden. Und ich denke, dass es notwendig ist, darüber eine Debatte zu führen. Und deswegen sind wir heute hier, weil viele Leute können sich das überhaupt nicht vorstellen, dass es solche Situationen gibt in der Europäischen Union, wo die selber ja immer so tut, als wäre sie für Pressefreiheit, für Meinungsfreiheit ein Symbol für Rechtsstaatlichkeit und für demokratische Prinzipien. Und ich glaube, es ist notwendig, diese Debatte zu führen, um weiter darüber aufzuklären, welchen Gefahren diese Prinzipien unterworfen sind. Und deswegen sind wir hier und ich freue mich sehr auf die Diskussion und möchte jetzt gerne Hüseyin Doğru das Wort erteilen, der jetzt leider nur im Bildschirm zugeschaltet werden kann. Danke.
First of all, thank you so much, Ruth and Michael, for organizing this very important event and giving me the opportunity to talk today. I hope I'm not going to be too long and I'm not going to bore you so much. As some of you might know already, my name is Hüseyin Doğru. I'm a German citizen, a father of 3, a journalist, and the founder of now defunct Red Media. I was sanctioned, as already mentioned, last year, May 2025. There was no criminal conviction, there was no trial, and there was no court that examined any evidence against me. I was placed just on a list. The reason given was not violence, it was not incitement, it was not finding by any court. The reason was political. My journalism, my reporting on Gaza, and my coverage of Palestine solidarity protests in Germany and across the world were folded into a language of Russia destabilization, information manipulation, and hybrid warfare. Germany has spent years trying to criminalize Palestine solidarity through bans, police violence, smear campaigns, and allegations that often collapse when they meet a court. Where there are no grounds to bring criminal charges, another route becomes attractive, not the court, but the listing. I cannot prove in this room which government pushed hardest for my listing, but the available facts that we have and my lawyers have point strongly towards the German government before Brussels listed me. German intelligence was already monitoring Red Media and me because of our pro-Palestine coverage. At the same time came the smear campaign in the German media. Then came the European listing. The EU listing describes me as a Turkish citizen. I'm not a Turkish citizen, I'm a German citizen only. I do not have dual nationality. My lawyers informed the council of this error, even the German government. But still, until today, I'm listed as a Turkish citizen. Even the German government refers to me, or referred to me a very long time as a Turkish citizen. This is not a small clerical mistake. It is far easier to digest if the public is told that the EU has sanctioned a foreigner. It is much more difficult to admit the truth that the European Union has sanctioned one of its own citizens living in Europe for journalism. Since then, my bank accounts have been frozen. I'm banned from working. I'm effectively living as an exile within my own country. And as already mentioned at the beginning, I'm not even allowed to attend this event to talk about press freedom. Additionally to all of that, at some point later, even my wife, who has not been sanctioned and who has nothing to do with this, had her accounts temporarily frozen, a move that can only be described as a collective punishment. I cannot buy nappies for my babies or medication for my children. And if you buy them for me, as already mentioned by Ruth, you could be persecuted for that. According to the new German law, up to 10 years in prison. This is why these sanctions do not only target me. In practice, they punish my entire family, including my 2 newborn babies. But this speech is not about my hardship, it's not about the problems that I'm suffering every day and all the people who are being listed. It's about what my case or our cases reveal about the state of democracy in Europe, or rather its erosion. A sanctions regime that decides guilt without a court is a shield for democracy, but it's graveyard. Before I explain how this sanctions system works, I want to be concrete about the evidence used against me, because that's the most interesting. Or rather the absence of evidence, which is itself the most damning evidence of all. After my lawyers asked the council to reconsider the sanctions, the application was rejected. The evidence used to apply the sanctions was described as confidential. I'm effectively forbidden from publishing the full evidence dossier used against me. The sanctions listing frames my reporting as undermining and threatening EU stability and places it inside Russian disinformation efforts. But the evidence pack does not prove that. It does not show Russian control, it does not show criminal conduct, it does not show that my journalism was directed by any foreign state. On none of the 38 pages of the evidence pack is there even the word Russia once mentioned. Instead, it cites journalistic posts of mine and political opinions as disinformation. It cites my criticism of Chancellor Merz and European weapons policy, where I described the war in Ukraine as an inner imperialist war, the same Marxist concept that once Lenin used in 1914 to describe the First World War. That is not a pro-Russian position. It treats Russia as an imperial power, not as a force to be celebrated. The evidence pack cites factual reporting that German intelligence was monitoring Red because of our pro-Palestine coverage. Again, this is classified as disinformation, and relies on guilt by association. Smear published in German media that some of our team had worked for an outlet funded by Russia. There is no proof here of a crime, no mention in the evidence pack of financial ties to Russia's state propaganda apparatus, and no mention that my journalism was directed by any foreign state. If this can be called evidence for sanctions, then ordinary journalistic work, reporting, criticism, opinion and political analysis can be turned into evidence against a journalist. If this can be disinformation, then dissent has become disinformation. If this can be called a hybrid threat, then political opposition has become a security problem. EU sanctions were not originally designed for cases like mine. They emerged from a history of embargoes and foreign policy coercions. And embargoes had already shown their brutality in Iraq, Cuba, Iran and elsewhere. Entire populations were made to suffer in the name of changing the behavior of governments. An estimated 500,000 children in Iraq paid the price for that. Medicines disappeared, economies were strangled, and still the promised political results never came. So these called smart sanctions were presented as a humane alternative. Not whole societies, we were told, not ordinary people, only individuals, only decision makers, only those responsible should be targeted. But the same underlying problem remained: extrajudicial punishment imposed politically with disproportionate consequences and weak legal protection. They were not designed as a mechanism for disciplining journalists or domestic dissent, at least until now. But step by step, they expanded. First, they targeted those labeled terrorists. and too few people spoke up because the word terrorism was enough to suspend security. Then they targeted enemy states, and too few people spoke up again because the language of security was enough to suspend doubt. Then they targeted oligarchs, companies, broadcasters, families, associations, facilitators, alleged networks, and still too few people spoke up because even expansion was presented an exceptional temporary necessary. Pastor Martin Niemöller once warned us how repression expands. First, against those we are told not to defend, then against those we think they are too far from us, and finally against those who thought silence would protect them. But exceptional powers rarely remain exceptional, and each silence becomes permission. Each precedent becomes a platform, each emergency becomes a method. Then came the conceptual leap. Sanctions extended into field of information manipulation and hybrid threats. The target could now be a journalist like me, a media platform like mine, a publisher, a person involved in the production of circulation of information. The foreign policy tool had entered the domestic public sphere. So how does this regime work? In my case, it worked like this. Formally, the process is administrative and politically. The Council adopted the decision under the Common Foreign and Security Policy. It then adapted regulations. My name was added to an annex. Once published in the official journal, the measures took immediate effect before I had even been notified. I had no prior hearing, I had no criminal trial, no court was required to find me guilty beyond reasonable doubt. The standard was lower, the language was sufficient grounds. I received the reason after the fact, and only then could I submit observations. But by then, the punishment had already begun. My accounts frozen, my work blocked, and stigma attached. I was isolated first. What came later was not a meaningful defense. It was fight against punishment that had already begun. So, in reality, my listing is an administrative act with consequences even more severe than a criminal conviction. That sentence matters because the EU insists that sanctions are preventive, not punitive. They are not, we were told, punishment. They are instruments to influence behavior. They are foreign policy measures. But what does that mean when the target is a journalist here at home in Europe? Does it mean I'm being sanctioned until I report differently? Until I stop questioning the German or EU policy? Until I stop documenting Palestine solidarity? If the purpose is behavioral change, then let us say clearly what the goal is here. I'm being pressured to change my political speech. I'm being punished until my reporting becomes compatible with the EU foreign policy, as they say. I'm being made into warning to others. These are not merely financial measures, they're disciplinary measures, a warning to every journalist, publisher and dissenter that political non-conformity will not be tolerated by the EU. And because sanctions are formally not punishment, the guarantees of criminal law do not fully apply, sometimes not at all. That is the legal contradiction at the heart of the system. Due process, the presumption of innocence, the right to know the case against you, the right to challenge evidence before punishment takes effect. These are not technicalities. They are the minimum protections that stand between the individual and the power of state. In dubio pro reo means, when in doubt, protect the accused. Sanctions reverse that. I was listed without trial, without a prior hearing, and without full access to the evidence. Doubt did not protect me, it punished me. So the principle becomes, when in doubt, not protect, but restrict the individual. Time itself also becomes punishment. A case before the general court can take years. In the meantime, my work, finances, reputation and family life being destroyed. The court may later say there was an error, but the consequences have already happened. When guilt decided without a court, sanctions cease to defend democracy. They begin to dismantle it. There is also a broader political context. Russia is the central justification. China is increasingly folded into the same strategic vocabulary, along with a growing list of other countries. The language is de-risking hybrid threats, foreign interference, information manipulation. Let me be clear, this is not a defense of any government at all. It is a warning that Europe is beginning to reproduce the very methods it claims to oppose. We accuse others of silence and dissent, of treating journalism as a security threat, of using administrative power to discipline political speech, of replacing public debate with loyalty tests. But it is this, if not the same, logic translated into European language. And in Germany, this legal shift is connected to a wider political economic shift. Germany is militarizing, not only rhetorically, but industrially. Its economy is stagnant. Its old industrial model is under pressure. Its car manufacturers face competition they can no longer easily dominate, especially from China. And now parts of that industrial base are being redirected towards defense production, a pattern whose consequences we know from the darkest period of recent German history. Lenin analyzed once the dynamic over a century ago. In Imperialism, the highest stage of capitalism, as he says, he described how monopoly capital, when it encounters limits to profit at home, turns to military expenditure, to armaments production, to the export of capital backed by the export of force. War is not an accident of imperialism, it is its logic. Because Germany is one of the EU's dominant powers, this militarization becomes Europeanized. A permanent atmosphere of threat is needed to justify it. Russia, China, migrants, protest, journalism, even Palestine solidarity. War becomes the answer to economic decline. Rearmament becomes an industrial program. Dissent must be managed because a society being prepared for war cannot tolerate too much public doubt. This brings me to the central arc of the speech, the militarization of information. Marx described ideology as a superstructure that corresponds to the economic base. When the economic base reorganizes around war, the ideological superstructure must also reorganize around war. Public debate must be made safe for rearmament. Dissent must be managed. Journalism must be made complaint for impossible things. If Europe is to be reorganized around war, then public debate must also be reorganized around war. Sanctions against individuals and content regulation through Digital Service Act may appear to be separate fields, but they are not. They work toward the same goal, the management of the public sphere through the language of risk and threats. Under the DSA, platforms must assess and mitigate systematic risks, including disinformation. At the same time, the EU foreign policy language has shifted from disinformation to FIMI, foreign information, manipulation and interference. Disinformation at least appears to ask a question about content, and is it true or false, even though there is no legal definition of the term disinformation. FIMI asks a different question: who is speaking and in what tone? Are they hostile or friendly? And the EU's own definition is revealing. FIMI does not concern illegal contact. It describes a mostly non-illegal pattern of behavior that is set to threaten or potentially negatively affect values, procedures or political processes. Mostly non-illegal, that's the most important part here. That phrase should alarm every Democrat in this room, because if the behavior is mostly non-illegal, then the issue is not crime, it is interpretation. It is political labeling. It is the power to decide who is treated as a threat. The question shifts from what was said to who said it. That is where sanctions and the DSA meet. One acts on the person, the other acts on the space in which the person can speak. Together, they create a system in which the state does not need to be a newspaper. It is enough to list its founder, freeze accounts, frighten its bank, frighten its platforms, and the whole process democratic resilience. But it is not resilience, it is censorship by infrastructure without a censor signature. It is censorship carried out through banks, platforms, payment providers, compliance departments, and risk managers, so that the state can say, we did not silence you, the system did, or in this case, the EU did. This is how power is privatized or exported, in my case, from Germany to the European Union. And let us be honest about Palestine. A long list of genocide scholars, legal experts, and human rights organizations have confirmed that Israel is committing a genocide in Gaza. There are proceedings at the International Court of Justice. There are mass grave starvation, the destruction of hospitals, schools, universities, and entire neighborhoods. Europe is not a neutral observer. Europe is politically, diplomatically, and materially implicated in this. So when journalism documents protests against that complicity, it is not destabilization. It is a journalistic duty and the minimum moral response to mass slaughter. When reporting on protests becomes evidence of destabilization, the state has stopped treating journalism as a democratic function and started treating it as an enemy. The question is no longer, did this person committed a crime? The question becomes, does this weaken our narrative? When the field of public debate adopts military vocabulary, risk, threat, manipulation, freedom of the press is no longer a right. It becomes a security question. That is why I'm not here to ask for sympathy. I'm here to say something simple. Sanctions must never be used as a tool of suppress speech. Journalism should never be sanctioned. Not because every journalist is right or every report is beyond criticism, but because the answer of journalism is more journalism, public debate, evidence, correction, and when necessary, a court of law. Not secret files, not administrative lists, because democracy is not defended by bypassing its courts. I want to remind you to what I said, or I want to remind you, I stand before you today not because I was acquitted. I stand before you because I was never charged at all. And that precisely is the problem. A sanctions regime that decides guilt without a court is not a shield for democracy, it is its graveyard. That's it from my side for now. Thank you so much.
Vielen Dank, Hüseyin. Das war sehr umfassend und hat das ganze Geschehen in einen größeren Kontext gestellt, der aber natürlich genau dahinter steht, hinter den Sanktionierungen und dem, was wir hier erleben. Und ich würde jetzt gerne weiterleiten an Juan Branco, der auch eine ganz besondere Perspektive mitbringt. Wie gesagt, er kennt sich aus mit dem Fall von Julian Assange, der ja anders gelagert war, aber wo es natürlich auch Ähnlichkeiten gibt, dass man Stimmen zum Schweigen bringen möchte. Und er ist jetzt befasst mit dem Fall von Nathalie Jamp und wird uns erläutern, was die Besonderheiten in diesem Fall sind, der anders gelagert ist, weil Nathalie Jamp ja keine EU-Bürgerin ist, aber es trotzdem deutliche Implikationen hat für das, was wir hier erleben. Und deswegen würde ich jetzt das Wort an Juan geben. Dankeschön.
Thank you very much. Thank you for the invitation. Thank you for attending. I regret not being able to do this speech in French for my sheer sovereignism and defense of French language, but I'm very glad to have the opportunity to speak about this case and the situation of Nathalie Jamp, whom I have had the honor to represent before the General Court until recently. Nathalie Jamp couldn't come either because she's prevented from entering into the European Union territory, but she has a more specific situation which I think was not foreseen by the legislators of the EU and the implementators of those legislations, which is that Switzerland is an enclaved country, an enclaved territory, and that the moment she was sanctioned, Nathalie Yomb was in African continents. And as with the previous speaker, she was not, of course, warned in advance because the sanctions are considered to be only effective if they take by surprise those who are exposed to them. So she literally discovered that she was in the sanction list and unable to fly over EU territory whilst in Kenya. And she lives in Switzerland. So she was basically unable to come back to her household, to meet with her family, to keep on working, and has been locked outside Switzerland for since June 2025. So this is a very specific situation that violates, of course, numerous international conventions, like the Barcelona Convention, but also principles of international law, like the protection of the right to return to its own country. And we've had these very interesting and nice dialectics with the Council of the European Union about the situation, and through the General Court, to ask them how could they consider that they could prioritize these legislations and regulations over these international conventions EU members are signatories and the EU should respect. And of course, it's a very embarrassing situation, and I think they weren't, what I was saying, I really believe so, that they didn't foresee the difficulty here. So they tried to explain that although flying over the EU is actually explicitly signaled as a forbidden activity, and it is effectively implemented. Nathalie Yomb cannot book any flight to come back to Switzerland. It's systematically cancelled. They say that the interpretation that should be given to the text, the applicable text, is not this one, and she can actually fly back. Whether she could fly away again is uncertain, but so they try to mingle around, and they rely on one of the facts that has been announced by the previous speaker, is that the proceedings before the General Court are extremely long, and because there is no previous contradictory phase, the sanctions are effective until you get an answer from the General Court, which at some point will come in a few months, so probably more than a year after the decision was taken and the appeal was filed before the General Court. And this decision will probably say that actually Nathalie Yomb is able to return to her country, because I don't see how they could do otherwise in the conventions I have just mentioned. And in that moment, will Nathalie Yomb be able to go to the flying companies, to whatever flying business she will have to take, and present the decision and tell them they actually have to let her board inside the plane. But until then, of course, because of this issue, she will not be able to. So that's the reason why she cannot be here. Not only can she not be here, but she cannot even be in her home country in Switzerland. The second specificity of this case is that Nathalie Yomb, and the extension of the regime of sanction has been well described, has been sanctioned for only one fact. She's been sanctioned for having participated in a conference in Berlin that was financed by an NGO, which is said to have been financed by Wagner Group. So she went there, she didn't get a fee for participating in this conference. There were MPs, German MPs, that participated in this conference. And this sole element justifies in the Council of the European Union decision that she's placed in this sanctions list, that all her accounts are frozen, and that she's unable to fly over the EU or into the EU. Nathalie Yomb is one of the most influential Pan-Africanist intellectuals, and she's been a long time enemy of French neocolonial policies in the African continent. She's been for more than 20 years, so well before Russia ever took any interest in those questions. And she became a very effective force in trying to reduce the effects and the capacity of French authorities to mingle into internal African affairs. She's followed by millions of persons. She's extraordinarily charismatic. And she gave a speech in Russia, in Sochi, in which she called for the independence of all countries of Africa and all peoples of Africa against all forms of neocolonialism, including Russian neocolonialism. And in this circumstance, she has either called or considered that the alliances between in particular Western African countries and Russia, could be an effective way to try to dismantle French neocolonialism. And this is the actual reason why she's been sanctioned through Ukraine-Russia legislation. So the legislation on the sanctions which is applied to her is related to the discourse on the Ukrainian war. But this is just an instrument, a tool that has been used and manipulated by French authorities to have her put into the sanctions list. And we know so well that it's actually France who's behind the move, that the Council of the European Union was actually short of arguments when we presented our case before the General Court of the EU. So they did this very strange move, and very unusual for those who know these kind of proceedings, is that they asked the court for an authorization for the states to participate into the proceedings. They wanted basically France to provide some reasoning about why was Nathalie Yam been in the sanction list. As you know, it's the Council of the European Union in its Ministries of Foreign Affairs composition that takes those decisions, and it's the initiative of one of the state members that triggers these sanctions, but the vote for the adoption of the sanctions. But these elements and the deliberations between the state members are not accessible to those who try then to protest the decision and to appeal before the General Court. The reality for me is very simple. Even if Nathalie Yam, who's a very funny and provocative person, who's been calling, just to give you an example, in a joking matter today, to sink the Charles de Gaulle, which is going to the Strait of Hormuz, and calling the Iranians to try to put it down. Even if she was on the Russian payroll, I would need evidence for that as a lawyer and as a citizen to try to verify that the claims are actually true, and to try to understand, aside from that, if any legal structure, any legal text actually prevents her from being under this payroll. And if there is no criminalization of the fact of being under Russian payroll, well, maybe one should be adopted. And it's up to the legislators and to the citizens to debate whether external funding from an EU country is acceptable, and if using external funding and having political positions that can be provocative or transgressive should be a criminal offense. By avoiding this debate, by avoiding the fact that the adoption of such legislations, the EU states have given themselves a capacity to actually destroy the lives of individuals without giving them any access to any sort of fundamental right, contradictory debate, and so forth. There is the proceedings before the General Court are virtual in their effect. The General Court considers that because this is a PESC matter, because it's a the foreign affairs and political affairs question, the scrutiny of the General Court and of courts over those decisions should be extremely limited, and basically limited to mistakes regarding the identity of the person or the facts that have been alleged to have been committed by this person. Factually, even the very rare and very, very rare times in which the General Court has reverted a decision from the Council, the European Union Council, the Council of the European Union, sorry, even in those circumstances, the Council of the European Union have just again taken the same sanctions, slightly changing the motivation, so to start again the proceedings that last for years, and thus actually having an effective implementation of this situation. So we're in a very specific and strange situation, because those sanctions have a worse effect and a much more impact than most criminal decisions, most criminal sentences that are taken in the European Union countries. If you look at the average sanction, criminal sanction for having committed actually a criminal offense, and if you compare it to the consequences that bring you to be deprived of your resources and or your capacity to reach your home country or a EU country, you actually realize that most of the crimes are sanctioned in a way lesser important and violent way. And you have to add to this first issue, the second issue, which is the uncertainty. You have, when you get a criminal sentencing, you know exactly for how long you will be sentenced, and then you're able to be rehabilitated. And you have this capacity to understand that for this moment of your life, you will be either deprived of your freedom, either deprived of some civil rights, and then you will be able to carry on. In the current circumstances and through this legal system, there is no way to know for how long it will last. Sanctions are automatically renewed. In reality, there is no verification of their usefulness, and there's been people who have been sanctioned for more in the sanction list for more than 10 years, so it's actually indefinite. And this is one of the main arguments the General Court makes to actually pretend that there would be no issue with the fact that you don't give prior contradictory access to the evidence and capacity to raise your arguments, is that they pretend that the sanctions are by definition limited in time, which is legally true. It's supposed to be renewed every year, but actually not true because there is no actual debate over the renewal of these decisions. And it's the same way for the capacity for, I mean, it goes the same way for the capacity for the people who are being sanctioned to actually ask the Council of the European Union to unsubscribe them from this list. In reality, there is no effect to those demands. The other issue, and I could go on for hours, so I try to focus on the main ones, is the evidence case that is provided when you go to the General Court. I was very surprised and actually very amused by the fact that in a system that is meant to stop foreign ingerences, to foreign interventions into the democratic space of the European Union, 90% of the evidence submitted to justify the sanctions about Nathalie Yom were from NATO-funded think tanks, most of them from Brussels. And you have a few articles, maybe the two only ones that come from a relatively neutral press organ are one from the RTS, so the the Swiss national media, and one from Le Monde, but both only pick up from the same sources which are related to this participation to this Sochi event. I need, when you have such high consequences on your life, I need to be presented with the evidence to actually be able to defend my client. The EU justifies the fact that they only provide with public accessible sources, theoretically to respect the rights of the defendants, which is completely absurd and ironic, because actually if we're not hypocritical about what is going on, this is all about secret services work. So it's very possible that secret services have elements on those persons who are being sanctioned that could hint that there's been connections or not, but we're unable to know which ones, and they actually consider that the real reason is that they consider it a security reason. They want to make sure that how they surveil those people is not revealed, and the extent of this surveillance is not revealed. And if we cannot either know what's the scope of this surveillance and thus the evidence that have been taken, and whether it's actually serious or only hearsay, or even communicated by third parties who are trying to limit the activities of those individuals, where of course we find ourselves in a situation in which naturally the jurisdictions are going to start to be instrumentalized as it is in the current situation. I'm pretty sure the only evidence the French have over Nathalie Yom is related to the fact that she's been the most powerful voice against French influence in Africa, and that's all. But they can convince their counterparts that they have elements that they cannot share that show that she's actually compromised by a third party. And then I come back to the evidence case file. So if you are accused of being the spokesperson of a foreign country, and if this is a ground for sanctions, how is it that all these people that work on these NATO-related think tanks are not sanctioned? I mean, NATO has formally no link with the EU, or it has with EU members, but we're talking about EU legislation. And so where is the credibility, especially if you know that NATO is so implicated in European-Russian conflict, which is not the case today of EU. There is no declaration of war against Russia today. And then we fall back to the last element, and the last problematic element in these cases. This hybrid warfare idea, which is codified nowhere which corresponds to no international law concept, which is just a way to extend the scope of exceptionalism of the state intervention. This is very Schmittian. I don't know if you know this Nazi philosopher Carl Schmitt, who's been one of the main inspirers of the legislations of exception, which justifies the fact that the state should have an exception, capacity to create exceptions to the rule of law, to intervene wherever he finds it natural. This is exactly what we are using in terms of structure of thinking to apply to these current circumstances. And I'm not using Carl Schmitt to pretend the EU is Nazi or so forth. It's just that Carl Schmitt is actually a very influential thinker in a lot of elites and legal elites, and is taught in French universities, in the legal universities and so forth. So it's actually an influence that has ended up triggering the adoption of these kind of systems of law and these dispositions. And so you have the sanction system, which per se is problematic, and we know. And actually, if the EU was actually independent from any other foreign power, the first thing it should have done would have been to fight against the sanctions as an idea, and against the US sanctions, which have been those who have been used against a lot of EU actors. Then you have, on the contrary, the implementation of these instruments in internal legal EU system, and then you have to find a way to have them being applicable in any possible system, in any possible situation. And so you invent this concept, this non-concept of hybrid warfare, which basically allows you to extend yourself in any domain, including the most precious one for any liberal democracy, which is freedom of speech. And that's how you grasp freedom of speech matters, which are in theory the most protected by European conventions and so forth, and you bring them to this exception system of law, and make sure that all the protections that have been adopted to try to avoid the catastrophes, the political catastrophes this continent has known, well, you manage to find a way to circumvent them. So this is basically the main problematics I see in those proceedings. And actually, I'm talking about proceedings, but this is just arbitrary system. There is no proceedings. I mean, there is proceedings. We've filed 50 pages of arguments, and we've gotten response from the Council of the European Union, and we pretend that there is something happening around the General Court in these situations. There is a slight hope that things might change, because these cases, whether Jacques Beau, whether Nathalie Yom, whether the previous speaker, are about, for the first time, freedom of speech. As he was saying, it's not about oligarchs, it's not about weapons dealers and so forth. This is about citizens who are just sanctioned for having thought differently than others, to having translated their reality in words that are not convenient for our current elites and current politicians. And this is, of course, maybe a limit that might be picked up by the General Court, and maybe they will find the courage for, at last, try to set a frame that will be more restrictive than the one that has been adopted until now. But I would finish by saying that, I mean, this is no longer anything related to rule of law. We're really in a rule of war system, and without maybe picking up on I think you can read it from a Marxist perspective as it was just exposed, but if you read it from a liberal perspective, it's exactly the same. We were preparing ourselves. Maybe there has been some evolutions temporarily because of Trump's election and the evolutions of the foreign affairs policies of a country that we're meant to be independent from. But structurally, we've seen the EU system prepare itself to wage a war, and prepare itself to wage a war against a third country under the pretext that there was a conflict between a non-EU country and this third country, which is Russia. And we've been readying ourselves to get to the point in which we will be able again to mobilize and lock in the populations in a war situation, which of course would escalate in such way that we would find ourselves again with conscription and general mobilization and so forth, because there is no way to confront a nuclear power like Russia otherwise than with mobilizing the whole populations. And to be able to bring us to there, we of course need to limit freedom of speech. There is no wartime without limitations of freedom of speech. And hybrid warfare is just a preemption of this path to war that we might escape from, but we might not. And cases like Nathalie Yom And others should not rely, and the denunciation of those cases should not rely on the sympathy that you have towards those individuals, their compromission or lack of compromission. It should rely on the fact that you're not only attacking some abstract rule of law, principles, that so forth, that basically only us in Brussels and in the capitals understand and try to grasp in these abstract ways. We're actually attacking the possibility for our continent and thus ourselves and our children to actually live in peace and be able to voice their concerns before some people that direct our destinies decide to launch us into a war against a third country.
Vielen Dank, Juan. Du hast das sehr gut und interessant eingefügt in die aktuellen Entwicklungen, wie ich finde. Und ich würde jetzt gerne überleiten zu Alexandra Hofer, die zu dem rechtlichen Hintergrund noch etwas sagen möchte. Und zwar, sie ist Sanktionsexpertin und hat sich intensiv mit der Thematik der Sanktionen und wie es überhaupt dazu kommt, dass es Sanktionen gibt und wie sich die Situation mit Sanktionen, internationales Recht, Sanktionen und EU-Sanktionen verhält. Und das, glaube ich, wird das Ganze nochmal auf der rechtlichen Ebene einordnen. Und deswegen freue ich mich auf Ihre Worte.
Okay, thank you very much. It's a pleasure to be here. I have to say I feel slightly intimidated to come after those very powerful presentations by Hussein Dogru and Juan Branco. Although I guess I have been researching sanctions for the past 10 years, I always wanted to leave sanctions, but then something else happens and I'm brought back in. So my resolution for 2026 was, okay, time to move on from sanctions. I'm sick of sanctions. And then I was really struck when I saw that I knew that this destabilizing activities against sanctioning Russia for its destabilizing activities existed, but it was kind of the back of my mind. And then I was just reminded of it, a bit like a shock, a jolt to my system in December 2025, when I saw that Jacques Beau, who was a very active commentator, had been sanctioned. And I personally never watched Jacques Beau. I'd heard of him, but I never watched him. Well, okay, if the EU didn't want people to watch Jacques Beau anymore, well, I started watching Jacques Beau to see what all the fuss was about. And then you realize that you are seeing just a very, I would describe him, a reasonable human being, giving his perspective based on his expertise of current geopolitical events and how the EU and NATO are responding to these events. That's basically what I saw. Now, the EU described Jacques Beau, and we've had the example of Hussein Dogru, of Nathalie Yam. He is a Russian mouthpiece who is spreading conspiracy theories. And then they gave an example of a conspiracy theory that he allegedly spread. And, you know, in one of his interviews, he said, I never said what they said I said. I was actually quoting someone. And because I'm a lawyer, I thought, okay, I'm going to go fact check. And I indeed found the quote that he was talking about. He was quoting a former advisor to Zelensky, you know, who was talking. I'm not going to say exactly what he said because I don't remember and I don't want to be accused of spreading conspiracy theories myself. So that's the world that we live in. And so, okay, so I'm a sanctions lawyer. I approach, usually the sanctions I do are what we call economic, financial, or sectoral sanctions. So the sanctions that we have against Russian gas. I don't usually focus on individual sanctions, such as the ones that we're talking about today, resulting in asset freeze or travel ban. And I'm not a human rights lawyer. Essentially, what I am is, I guess, someone who has always been very critical of sanctions. So oftentimes, we justify sanctions because they are considered to be non-violent in the sense that, well, they're a good alternative to war. We're not literally killing someone, you know, we're just imposing financial and economic pain. which is interesting because the word pain is used to describe sanctions, but sanctions are not violent. So I don't know. It seems to me that it's what we would call another form of violence. So let's say economic violence, or what others might have referred to as systemic violence. And I think when we consider the consequences of living under sanctions that are experienced by Hussein, by Nathalie, by Jacques, it's really a form, and it's been used. Former Attorney General of the EU that worked at the European Union describes sanctions as, living under sanctions is a civil death penalty. Attorney Gavin Sullivan, so he worked with individuals who had been placed on the counterterrorism list of the UN Security Council. He really describes sanctions as a form of cruelty that you're imposing on these individuals. And everything we've been hearing about today has always been a problem. It was a problem when the UN Security Council, as far as I know, first started adopting targeted sanctions against individuals that were considered to be terrorists. Now, one of the issues with the label of terrorism is, well, it's kind of hard to define what a terrorist is, right? Famously, there's no international definition of terrorism because, as the saying goes, one man's terrorist is another man's freedom fighter, so it's very hard to get countries to agree. So how did the UN Security Council proceed? Gavin Sullivan wrote this really powerful book, The Law of the List, where he described, his experience with the sanctions, the interviews he had with people who designed the list, who came up with criteria in order to place people on the list, who interviewed judges. Okay, how do you assess when you're listing all these? He really looked at it from a very holistic perspective. And it was really very sobering because you would think, well, this is the UN Security Council. So this is the organ that's charged with international peace and security. They have highly qualified, highly intelligent people. You really have, let's say, almost the elite of the world that are there, right? You have high-ranking officials from the United States that are there. So if anybody knows how to design a sanctions list, well, it should be these individuals. What was really shocking was to read how in many cases people were listed for practically no reason. You would be suspected of being a terrorist because you liked a Facebook post. Or maybe you were added to a list because as a political favor, there was a case of an Italian who was added to a list as a political favor to the US. And so he really describes a very callous system with people who seem to not really care about the consequences of their actions. And what I found really shocking is we give these organs and these institutions a lot of power because we trust them to do their job properly. Now, why did I kind of do this long segue to the UN Security Council? I wonder if we're kind of having the same issue here with the Council of Europe, because as I said, so the EU has been adopting sanctions for decades. And it's actually not the first time that individuals have been sanctioned because of their speech acts. There's Russian nationals who had previously been sanctioned already when the EU started to adopt sanctions in 2014. The EU in 2022, has imposed a ban on Russia Today, a Russian media outlet, and others. So that's when we had the first really sectoral sanctions against a media outlet. And it's been, let's say, interesting, I don't know if that's the right word, to witness how the EU has developed its own sanctions practice, especially when it comes to targeting Russia, because it has really, one of the characteristics, I guess, of all these 20 sanctions packages is that the Council has developed broader and broader sanctioning criteria. And of course, the other annoying thing about sanctions is the language is really complicated because it's quite abstract. But then you see how it's put in practice, and then you're maybe a bit shocked by the consequences. But if you look at the language that's given, the list that Hussein Doghu or Nathalie Yam have been placed on, so the idea is that the EU wants to counter Russia's destabilizing activities, and so such sanctions will be imposed against persons who are responsible for implementing, supporting, benefiting from, involved in, or facilitating actions or policies attributable to the government of Russia which undermines or threatens the democracy, the rule of law, stability, or security in the Union, not only of its member states, but also of a third country that may also undermine or threaten the sovereignty or independence of another country or of another member state. So what are the activities here? We have, again, very broad scope, very broad list. We're talking about, I guess, sanctions against foreign information manipulation and interference. So that would mean that the individual would be responsible for planning, directing, engaging in, directly or indirectly supporting or otherwise facilitating the use of information manipulation and interference. Again, we have this very broad criteria that are given that almost anybody could fall into this. And what's also interesting, if we look at the cases under discussion with Hossein and Nathalie, is that they're not even commenting on the war in Ukraine. One is commenting on protests that are speaking out for Palestinians, just recording what is happening. And the other is critical of neo-colonial practices in Africa. In my university, I have colleagues that work on decolonizing international law, so we should be aware of the power structures. So are we suddenly not allowed to talk about neo-colonial practices? I mean, maybe we're not as influential as Nathalie Yam, so maybe we have nothing to be worried about. Another individual who's on the list is a Russian scholar. Can't remember, he works for a very famous think tank in Moscow. I can't remember the name, unfortunately. But he was listed for his academic work. One of his academic work is that he describes sanctions as hostile acts. So, but he allegedly has ties with the Kremlin. I don't have ties with the Kremlin, so hopefully, I've previously described sanctions as hostile acts, so hopefully, I will not be put on the list. So I guess the question is, well, how did we get here? And then maybe, I don't know how we got here. I think it's maybe one of those things that develops incrementally, and we don't have sufficient checks and balances, and maybe as citizens we're not really aware what is happening, and I think we have a tendency also to trust those with power that they will use it responsibly, and then maybe we're a bit shocked when we realize, oh gosh, okay, what happened? But it's really interesting that this is, maybe just to take a step back, and I'll try not to be too long, because when I talked about the UN Security Council listing procedure against terrorist actors, initially when you were placed on the UN Security Council's list, you were not given a statement of reasons. You did not have the right, there was nobody you could appeal to. You had no, and you just found out from one day to the next you were on the list, and there was nothing you could do about it. So that is what, and so what these individuals then started to do is they started to turn against the country that was implementing the sanctions, because of course the UN Security Council sanctions are implemented by states. And in the case, if you're an EU member state, well, it's the EU that adopts the regulation, and then the member state is supposed to implement it. So there were European nationals that had been sanctioned by the UN Security Council, who then started to appeal the procedure before the Court of Justice of the EU. And the very famous case we have is the Caddy case. At first, the court refused to hear it because it said, well, no, you're talking about a UN Security Council sanction. There's nothing we can do. Whatever the UN Security Council says, we have to implement it, no questions asked. And then he appealed, and then there was this very creative, let's say, reasoning of the Court of Justice, which was, well, no, we are not questioning the UN Security Council decision. What we're doing is we're reviewing the implementing act of the EU. And we are considering that what the EU has done is insufficient to meet human rights, notably the right of defense. So this was a huge victory for Caddy, and basically it led member states to go to the UN Security Council and say, well, listen, you've got to improve your procedure because we're being accused of violating human rights, so you have to have reforms. So then there was reform. You could criticize, within the UN Security Council, they introduced the ombudsperson. I think, I'm not saying it's a perfect system, okay. But then, okay, that gave some hope that there's this body that can review sanctions. We have this Court of Justice within the EU, which is, I have to say, better than if you find yourself on the US sanctions list. I think you're even worse off. So at least in the EU, there is some judicial body that reviews the sanctions. And so I think there was a wave of litigation, after the Cadi case, so from 2010, the first half of 2010. And at first, the council was losing a lot of cases. So one of the issues was that it wasn't able to provide sufficient evidence to justify the listing. And then I think the council realized that the court doesn't really question the listing criteria. It only checks if the council is meeting its own standards. So then the council, I'm just guessing, I have no idea if this is what actually happened, said, okay, well, if the court checks that I'm meeting my own standards, all I have to do is set the standard in such a way that it's easy for me to justify. And so that's what the court does. It checks, is there evidence? Well, is there a statement of reasons? Which is the paragraph that is provided on the annex of a sanction. So you can see why the council has decided to sanction Hussein Doghu or Nathalie Yam. So is there a statement of reasons? And is there evidence to justify that? And so if the council isn't able to provide that evidence, then that can result in a delisting. But then, as was mentioned by Juan, well, that means sometimes the council just changes the criteria and adds the person to a list. So there was the case of two Russian oligarchs, Avin and Friedman, who were sanctioned. They were said to support Russia. However, the council was unable to provide evidence that they actually support Vladimir Putin. And so the council said, okay, well, we're going to sanction them because they're leading businessmen. So in order for them to be removed from the list, they would have to demonstrate that they are no longer leading businessmen, which probably means, well, I have to sell my business, right? So if Hussein Doghu, let's say the court will uphold the reason for Hussein Doghu, saying, okay, well, we're not going to question the council. We're going to consider that this is valid listing criteria. That means that Hussein Doghu indeed would have to change his behavior. He would no longer be able to comment on pro-Palestinian protests in Germany. And then maybe that would get him off the list, I guess. I'm not sure. The court has said that, and I think what's really important is that, so it doesn't engage in the substantive review. So as far as I know, apart from the Cadi case, no individual has been successful in arguing that the sanctions violate their human rights. Because sanctions, by their very nature, restrict human rights, but what you have to demonstrate is that it's provided by law, that there's a legitimate aim, and that it's proportionate. So often the provided by law criteria is met because there's a council decision adopting the restrictive measures. Often there's a legitimate aim because the council says, well, for example, we want to stop Russian aggression. So it all hinges on the proportionality of the restriction that's being imposed on the individual. And here is, I think, the difference between the Court of Justice of the EU and the European Court of Human Rights is that the Court of Justice doesn't really engage in the specifics of how this individual is affected by the sanctions. Whereas if you would have the European Court of Human Rights, they really look at it a case-by-case basis. So is the burden that is imposed on an individual justified in these circumstances? And as mentioned by Juan, the Court of Justice of the EU also kind of trusts the council that it does its own proportionality assessment, that it checks the impact of the measures, that it checks the utility. So the court is very deferential to the council. It always says that it has a broad discretion because its duty is to promote European security or European values abroad, and this is a political issue, so it's therefore not the court's place to question these things. And so for me, that's kind of how we got here. We trusted the council, we trusted the court, and maybe there was this indeed concern of Russian aggression, but I think that concern has ballooned, if I dare say it, into paranoia, where I don't really see the connection between broadcasting pro-Palestinian protests in criticizing neo-colonial policies and the destabilizing effect that this has on Russia. I think that individuals are allowed to be critical, or even if they're not individually critical, just broadcast criticisms without being under the influence of a foreign agent. And so maybe just to end, and this is the general comment of the Human Rights Committee on when freedom of expression can be restricted. And at paragraph 42 of this general comment, it says that the penalization of a media outlet, publishers, or journalists solely for being critical of the government or the political social system espoused by the government can never be considered to be a necessary restriction of freedom of expression. So I'm very curious to see how the court will deal with these cases. As mentioned, I hope that it will be a bit brave, perhaps, in engaging with these issues. But because a lot of this is actually allowed by the legal system within which we live, because we seem to think that sanctions are a good foreign policy tool, I don't think that courts framing or restricting or, putting more barriers on these measures will be sufficient. I really think that there needs to be a political discussion on sanctions. I know that oftentimes sanctions are justified because we are pursuing values that we consider important abroad. But in doing that, we don't consider the real life impact that these measures have on people. And I think, as was mentioned, it's not because someone, and it's oftentimes, for example, an individual will be listed because there's allegations that they participated in violations of human rights. What is that evidence based on, right? So do we assume that it's really different, like the fact that we get press releases or, a think tank produces information about an individual, like, is that sufficient evidence to list someone and potentially ruin their life? So I really think that there has to be a more serious conversation about the impact of restrictive measures. And also, if the EU adopts sanctions in this way, how is the EU really contributing to upholding the values that it considers that it needs to uphold in the wider world? Because if the EU is not careful, well, it will hurt its reputation and its own self-image as being, a normative actor in its international relations. Thank you very much.
Vielen Dank, Alexander Hofer. Das fand ich hochinteressant, weil es das ganze System der Sanktionen, wie sie sich aktuell zeigen, einfach in Frage gestellt hat. Und okay, dann würde ich jetzt nochmal Michael von der Schulenburg.
Yeah. Should I talk in English? Because I don't know if we have still translation English, probably most people understand. Yeah. Okay, thank you very much. I worked all my life in war countries outside, and of course the what happens internationally is very important. And I would like to say what here happens to Hossein or Natalie and Jack actually is it's a individual part of a much greater development which we're going through, a geopolitical development which probably ends a time of 400 years. It is a very important one because it means that we are going through a development presently where states which are not member of the Western world, and I would define the Western world as essentially NATO countries, are demanding their rights. They have now economic development, they have technology. I mean, the BRICS countries are already larger than the G7, not only economically, but also technology is much greater. So I think what we see now is a movement to a world which we have actually not recognized for many, many years, because Europe and later together with the United States, we thought we could dominate the world. We would decide what the world is going to go on, that is happening. We could do that very peacefully because it's actually a very natural process. I mean, the NATO countries together population is today something between 10 and 12%. And of course, the other 90% have also certain rights. And we should, and this is very important to see in this context. When we see how the West reacts is by destroying international law. It is a law, actually, the West has once introduced in the world. It is a Western creation. And by destroying it, I think we have to be very careful because we start to destroy ourselves. When you listen to the President of the United States who says, for me, international law doesn't count and treaties also not, it's also only my morality, we go back to a world where might is right. And if we hear the Canadian Prime Minister, who also spoke in Davos and jubilates this even and says, oh, finally, all these things about these principles and, you know, blah, blah, it's all an illusion. And now we come to the real world. We know decisions are always made by interests, and the interests are those who have the greatest power. This is exactly what we actually once introduced in the world after the 2 world wars and saying we didn't want to have that anymore. And we're destroying it now. The problem is only that I think we will not be the strongest. If I look at the war in Ukraine and in Iran, I think we are losing these wars. So we are not the strongest. So I think we're doing an enormous disharm. And if you look at certain issues, like, for instance, that the European Union officially says that they abide to the UN Charter, but in reality they say never that this was an illegal war. The attack on Iran. They never say anything about that Israel breaks the humanitarian law in Gaza and Lebanon and things like this one. We simply don't say that. So it is actually hypocrisy how we use this law. We destroy it with this one. And I think the worst of the whole thing is, of course, a decapitation strike. I mean that we have negotiations, and within 2 days of the negotiations, we kill the leadership of the opposite party, you know, using peace talks to kill the other side, not continue. We have to go back to the Middle Ages. This hasn't happened for a long, long time. Of course, in the past, you know, we lured them over, we want to negotiate, we want to make peace, and then we kill them all. This is something which was practiced very, very long time ago, and we are going back to this time. Now, the problem for us is also that when we destroy international law, we become now also destroy the law in our own countries and in the European Union, what we call usually the rule of law in our countries. I mean, what we do here with these sanctions against, it's something we did also in the Middle Ages. It's like bringing outlaws. I mean, there's some secret organization, usually in the old time there was a king, lettre de cachet en français, vogelfrei in Deutschland, and outlaws, of course, in England. Typical things that we just took people's rights away, and they were suddenly no legal personalities. And we are in the year 2026, and we're doing this again. And this is so frightening. So what we do in international law, we do also in national law. And I think we should all be aware, it is not only what Hussein experience or Natalie experience or Jaguar and other people experience. What we really do, we hurt ourselves tremendously. And this things has to stop, because the UN Charter was once a contribution by the United States. Of course, there was always problems with it, but to do it away like Mr. Trump does it, I mean, he destroys the legacy which we had given to humanity, and I think we have to defend this, all these type of things. So it's a bigger problem. But let me just say here by the end, I know Ruth and I, we worked on this together, and I must say, especially you, so I wanted just to say in the final, thank you, Alexandra, for you coming, and Juan to come, and special thanks, of course, to Ruth. She did so much work. I mean, I just sit here on the side because I didn't get all this, and she did, I can't imagine. I mean, to do something like this in the EU Parliament, which is tremendously hostile to us, is enormous achievement. And I mean, I don't know how you did it, and all the others. And I want to really thank you. But since you, Hussein, are here, and I see you just in front of me, I think my last words are, of course, for you. And I must just tell you all my sympathies for you, for your wife, for your 3 children, what this must mean to become an outlaw in a modern world. I think you are an example, how you speak. I think the calmness, and I have a lot of sympathy for you. And I find we are ashamed, we are parliamentarians in this parliament, and as a parliamentarians, our duty should be to defend the rule of law, to defend international law, and to protect peace. And we don't do anything in this parliament. This is a very strange place, which I think completely goes in the wrong direction. What it should really be. I must say, I feel ashamed sometimes to be a European Union parliamentarian. Thank you very much.